Welcome to Crime Before Modern Law. Here, we explore how crime and justice functioned before modern policing. If you find this topic interesting, feel free to leave a comment telling us where you are watching from. And if you would like to support the channel, a like or subscription always helps. For most of human history, a trial was not a single universal format. A structured way to decide a dispute or an accusation using the tools a society trusted at the time. Those tools could include oaths, reputation, witnesses, written records, community knowledge, religious tests, officials' inquiries, or voting by large groups. This program explains how trials were commonly structured before modern law enforcement and modern courtroom rules. The focus is the typical order of stages: how a case began, how it was prepared, what happened on the hearing day, how a decision was reached, and what happened after. Even across different periods, many older trial systems shared the same basic questions. First, who has the right to bring the case? Second, who has the right to judge it? Third, what counts as proof? Fourth, in what order is proof presented? Fifth, what happens if the person is found guilty or liable? When you listen for these questions, older trial systems start to make sense, even when they look strange by modern standards. In many places, trials were not run by police and professional prosecutors. Accusations often came from private people, local communities, or officials who had administrative duties rather than investigative training. And many decisions were made without the kind of long witness questioning that modern viewers expect. What follows is a structured walk through major historical approaches, moving from oath-based and community-based trials to jury-style voting courts, and then to more official inquiry-based courts. The goal is not to rank them, but to show their stages and order. 1. Before trial began, how cases were started. In older societies, the trial usually started only after an accepted method of accusation happened. The system's first stage was often not about evidence. It was about permission and procedure. Common ways to start a case included a private accusation by an injured person or family. This was common where the state had limited reach. In many places, if no one accused, no case existed. A public accusation by an official. Some systems allowed magistrates or local officers to bring charges, especially for offences seen as harming the community. A community presentment. In some medieval settings, local groups were expected to report suspected wrongdoers. The community saying that someone was suspected could trigger the next stage. A complaint in writing. In more record-based courts, especially religious or administrative courts, a written complaint could launch a formal process. At this starting point, many systems also required the accuser to accept risk. If the accusation failed, the accuser might be fined or punished for bringing a weak or improper charge. This rule helped control false or careless accusations when there was no modern investigation. 2. The first screening, summons, custody, and the early review. After an accusation, older courts usually moved to a screening stage. This stage often included a summons. Courts relied on local power to bring people to court, village leaders, sheriffs, or other officials. If the person did not appear, the court might impose penalties or treat it as admission. Custody or pledges. Instead of a modern jail system, many societies used sureties, people who promised the accused would appear. The accused might be held in a local jail where one existed, but custody systems were uneven. A preliminary inquiry. Some courts conducted an early review to define the issue, what is being claimed, what rule applies, and what is being denied. This early review often decided what kind of proof would be used next. In older systems, proof methods were sometimes fixed by custom. A certain accusation required a certain type of oath, ordeal, or number of witnesses. 3. Choosing the mode of proof. What would count as truth? Modern trials usually assume that truth is decided by evidence tested through questioning, with rules about relevance and reliability. Older trials often work differently. The court's major decision was sometimes which recognized proof method will settle this. Several major proof methods shaped trial stages. 1. Oath-based proof, compurgation, also called wager of law. In early medieval and early English settings, a common structure was oath-based. The key idea was that a sworn oath, supported by a set number of oath helpers, could be accepted as proof. Typical structure, accusation, and summons. The court determines whether the accused is oath-worthy, meaning eligible to clear themselves by oath. If allowed, the accused swears a formal oath of denial. Oath helpers also swear that they believe the accused's oath. They are usually not witnesses to the facts. They support credibility and reputation. If the required number and form are met, the case may end there. If the accused cannot produce oath helpers, or if the offense is treated as too serious, the case can move to another proof method. This created a clear order. The court's first focus was not a long argument about facts, but whether the proper oaths were completed correctly. 2. Ordeal-based proof. In some medieval Christian settings, ordeals existed as a recognized legal method. Typical structure, accusation, and summons. Court orders a specific ordeal. Religious or ritual preparation could occur. The ordeal is performed. An official assessment follows, sometimes after waiting days to see healing. Judgment is declared. The key point for trial structure is that the hearing could be short. The main event was the ordeal itself, and the court's role was to order it and then accept its result. After church authorities withdrew from ordeals in the early 1200s in Western Europe, legal systems that depended on ordeals had to change their proof structures. That change helped expand jury-based decisions and other methods. Third, combat as proof in certain settings. In some medieval contexts, a judicial duel could function as a proof method. Typical structure, accusation, and formal challenge. Court approves or denies the duel based on rules and status. Arrangements, place, weapons, and timing. Combat. Result is accepted as the judgment. Again, the trial stage is centered on permission, formal rules, and the result of the contest, rather than witness questioning. 4. Witness and document proof in inquiry-based courts. In some courts, especially those influenced by Roman law traditions and church courts, the preferred structure was investigation through witnesses and written records. Typical structure, written complaint. Court issues a citation, ordering the defendant to appear. The court defines issues in dispute. Witnesses are questioned, often by the judge or court officials, and written depositions are produced. Documents may be collected and reviewed. The judge evaluates the compiled record. A written or formally stated judgment is issued. This structure is less like a modern jury trial and more like a case file being built and then decided. 4. The hearing day, what happened in the courtroom or public space. Older trials often took place in public or semi-public spaces, open areas, local halls, religious buildings, or temporary court sessions when officials traveled. Many systems placed heavy weight on formality. The order of speaking, the words used, the presence of certain officials, and the proper calling of the case all mattered. A. Large citizen jury courts in ancient Athens. Classical Athens used large panels of citizen jurors, with procedures designed to reduce bribery and influence. A simplified structure of an Athenian trial often included 1. Pre-trial steps. A complaint is lodged with the proper magistrate. A preliminary examination helps define the issue and collect statements. The case is scheduled. Jury selection. Jurors are selected by lot from citizens eligible to serve. The goal is to prevent handpicking. The hearing, timed speeches and limited formats. The litigants, often speaking for themselves or with a speechwriter's help, present their cases. Speaking time is measured, often with a water clock. Evidence like laws or written testimony can be read aloud, sometimes with the clock paused for the reading. There is typically no long, private deliberation or voting, and decision jurors vote, often by secret ballot. Majority decides. In some types of cases, there can be a second vote on penalty after guilt is determined. The Athenian structure shows a key historical pattern. Trials could be highly ordered without resembling modern cross-examination. The sequence is complaint, preliminary review, random jury selection, timed speeches with evidence readings, and immediate voting. B. Roman Republican and early imperial approaches. Roman trial structure varied over time and by offense, but several patterns matter for understanding stages. In earlier Roman popular trials, the people assembled could hear arguments and decide. Later, permanent courts developed for certain offenses. A broad structural outline for some Roman criminal proceedings includes 1. Initiation. An accusation is brought under a magistrate's authority. A day is appointed for proceedings. 2. Preliminary meetings or hearings. There could be multiple public meetings where speeches and testimony were heard. Time and scheduling mattered, and delays could be tactical. 3. Formal trial session. A presiding official manages procedure. Speeches by prosecution and defense occur. Witnesses may be called, depending on period and court. A panel or assembly reaches a verdict. Roman systems show another repeating theme. The trial's order can include scheduled phases spread over days, with formal speeches central to the process. C. Early medieval local courts, community and status. In many early medieval local courts, including hundred courts and other assemblies, trials were community-based. A typical order could look like this. 1. Calling the case. The court meets on a regular cycle. Officials or local leaders preside. 2. Statement of claim and denial. The accuser states the charge. The defendant denies or answers. 3. Determination of proof method. The court decides whether proof is by oath, ordeal, witnesses, or another recognized method. 4. Performance of proof. Oaths are sworn, oath helpers appear, or an ordeal is ordered. 5. Judgment and penalty. If guilt is established, punishment or compensation is imposed. In this structure, a big share of the trial is not a battle of evidence, but a structured method for settling a dispute using reputation and religiously serious promises. D. Medieval and early modern England, the rise of jury-centered criminal trials. England's criminal trial structure changed over centuries. After ordeals declined, jury processes expanded. It helps to separate two different jury functions that appear historically: a presenting or accusing group. This group reports suspected wrongdoing. A trial jury. This group decides guilt. Over time, English criminal procedure formed a recognizable sequence. A simplified stage order in many later medieval and early modern English criminal cases includes 1. Accusation and indictment. Information about suspected crime is presented. A formal accusation document, an indictment, may be produced. 2. Arraignment. The accused is brought before the court. The charge is read. The accused is asked to answer, often by pleading guilty or not guilty. 3. Jury selection and swearing. Jurors are chosen according to local practice and eligibility rules. They swear to decide according to the evidence and their duty. 4. Trial phase. The prosecution presents the case. The defense answers. Witnesses may be heard. In many early periods, jurors could rely on their own local knowledge more than modern juries do. A verdict. The jury announces guilty or not guilty. 6. Judgment and sentencing. If guilty, the court pronounces a sentence. Sentencing could be shaped by social status, legal categories, pardons, or clerical protections in certain periods. This sequence, indictment, arraignment, trial, verdict, sentence, is a key historical backbone for later common law criminal trials, even though the details changed. 5. How evidence was handled. What proof looked like in older trials. Modern viewers often expect a trial to revolve around forensic evidence and detailed cross-examination. Before modern policing, older systems used different evidence practices. A. Emphasis on reputation and oath. When courts relied on compurgation, evidence was partly social. The system asked, is this person trusted enough to have supporters swear for them? This is not the same as deciding what physically happened, but it was a recognized method of decision in societies where written records and investigation were limited. B. Written proof and depositions in record-based courts. In inquiry-based courts, witnesses were often questioned outside a dramatic public trial scene. Clerks wrote summaries. The written record was central. This created a different order: gather testimony first, compile it into a file, judge decides from the file. Public speaking could be limited compared to modern trials. C. Speeches as the main event in civic courts. In Athens and many Roman settings, set speeches carried the argument. Evidence could appear, but the structure made formal speech a main tool. D. Limited defense tools in many periods. In various eras, defendants had fewer rights to counsel, fewer opportunities to question witnesses, and fewer formal rules forcing the state to disclose information. That does not mean there were no protections. Many systems had their own protections, like strict procedural steps, public voting, oath rules, or community oversight. But the structure was different. 6. Decision methods, how courts reached a verdict. Historical verdict methods generally fall into a few types. First, judgment by the presiding authority. In some courts, the judge, magistrate, or lord decided. 2. Judgment by a panel or assembly. In Athens, large juries voted. In some Roman contexts, assemblies or panels rendered decisions. 3. Judgment by community knowledge. Early juries sometimes acted as informed locals rather than neutral fact-finders who know nothing beforehand. 4. Judgment by ritual proof. Ordeal or combat outcomes were treated as decisive. These decision methods shaped trial order. A trial designed for a large voting body looks different than one designed for a judge reading a written file. 7. The penalty stage, sentencing and its place in the sequence. In many older systems, sentencing was not a separate modern-style hearing. It could be immediate, automatic, or strongly fixed by category. Common patterns include fixed penalties. Certain offenses carried set punishments. Two-stage decisions. Some systems separated guilt from penalty, such as a second vote on punishment. Status-based outcomes. Class, clerical status, and local privilege could alter what penalties applied. Financial settlements and amercements. Many courts relied on fines, compensation, or payments to the authority. Public punishments. Punishment could be a public display meant to enforce order in the absence of strong policing. The sentencing phase also connected to mercy systems like pardons or commutations, which could be built into political authority. 8. Appeals and review. What happened after judgment? Modern legal systems often include structured appeals. Historically, appeal options varied widely. Some systems allowed appeal to a higher official or ruler, rehearing in a different forum, petitions for mercy rather than a legal appeal. In other systems, especially where a large citizen body voted, the verdict might be final in practice. Where written records existed, appeals were easier to structure because a higher authority could review a file. Decisions were oral and communal, appeal could be harder. 9. Why trial structure changed over time. Trial structures changed when societies changed what they trusted. When communities were small and reputation mattered most, oath-based proof made sense as a structured decision tool. When religious authorities supported ordeals, ritual proof could be accepted. When states grew stronger and written administration expanded, inquiry-based courts and formal records became more common. When public civic identity was central, large citizen juries and open voting fit the political culture. When centralized governments needed consistent enforcement across wide areas, they pushed toward standardized procedures, professional officials, and later, modern policing. Across all these changes, the idea of a trial remained, a recognized sequence of steps meant to produce a final decision that the community or state would accept. 10. A simple cross-era summary of trial stages. To close, here is a plain sequence that can be used to compare many historical trial systems, even when the details differ. Stage 1. Accusation or complaint. A person, official, or community body brings the issue forward. Stage 2. Summons and jurisdiction. The court claims authority over the dispute and orders the parties to appear. Stage 3. Early review and issue framing. The court identifies the charge or claim and decides what must be proven. Stage 4. Choice of proof method. Depending on the era and court, oath-helping, ordeal, combat, witnesses, documents or speeches before a voting body. Stage 5. Presentation or performance of proof. The recognized proof method is carried out in an ordered way. Stage 6. Decision. A judge, panel, jury or assembly declares the outcome. Stage 7. Penalty or remedy. Punishment, fine, compensation or other consequence is imposed. Stage 8. Enforcement and aftermath. The decision is carried out through local authority, payments, custody, or public measures. Appeals or petitions may exist, depending on the system. Understanding these stages helps explain why older trials sometimes look unfamiliar. They often were not designed to discover facts through investigation in the modern sense. They were designed to produce a socially accepted decision using the kinds of proof and authority that people recognized at the time. That is the core of how trials were structured historically, a step-by-step process built around the society's trusted methods of accusation, proof, judgment, and enforcement, long before modern law enforcement and modern courtroom rules.